Addiction is not a separate grounds for divorce in New Jersey. However, if your spouse is suffering from an addiction, it certainly is likely to have impacted your marriage. You can always use one of the other fault grounds for divorce to claim that someone's addiction has an impact and caused the breakdown of your marriage, including extreme cruelty. If you plead extreme cruelty, you can detail exactly what you believe has happened in your marriage that caused your marriage to break down, and that can include the fact that your spouse has an addiction. The impact of an addiction on children is different from child to child. Obviously, you need to be concerned about your child's safety first and foremost. If your spouse is suffering from an addiction, you need to raise that concern in your divorce to make sure that all safeguards are taken to protect your child from the parent while they are actively under the influence of a substance. That would include making sure that they are attending rehab if that is a concern, or if they don't need rehab but they are at risk for relapse, that they engage in the appropriate service to ensure that they don't relapse during the time that they're caring for your child. In New Jersey, we do have a law, Newberg versus Arrigo, that allows a court to compel you to pay for your child's college education. One of the major considerations is whether or not you and or your spouse are college educated. If so, the likelihood is that the court is going to say that you would have made that choice had you remained together, that you would contribute toward the child's college education. A lot of factors have to be considered, including whether or not your child has the aptitude to go to college, what costs have been factored into the decision, whether or not your child is going to receive scholarships, aid, and the like. But there is a very extensive list of factors that have to be considered, and you really should consult with an attorney to get a definitive answer in your circumstances. Anytime that a person, a parent, is subjecting a child to a third party who may be committing acts of child abuse, the court and the agency are going to be concerned that the parent may not protect the child adequately. So it's not definitive that your girlfriend is going to lose her child simply because she has a boyfriend that has abused the child. But the extent of her knowledge and whether or not she is going to separate from that relationship will be considered. And if she doesn't, the court may very well decide that she is not adequately fit to have custody of her child. If you believe your child has been subjected to abuse or neglect at the hands of any third party, you can take action to go to court without the agency. The agency is not required to make a finding in order for you to assert to a judge that your child requires protection. In those instances, you may either file in family court or you may file a separate Title IX complaint that alleges that your child has been abused or neglected. The standards for assessing that issue remain the same whether the claim is brought by you or the agency. In order to assert that your child has been abused or neglected and to do so most effectively, you really should consult an attorney to get advice on your circumstances.